Breaking news, breaking news. Want to come to you just real quickly to talk to you about two lawsuits. So you all sit tight and we will be back in a second, okay? All right, we back. Again, I want to talk to you about two lawsuits that has been filed. It regards the Blytheville School District. Okay, well, I want to talk about those two lawsuits. Actually, it was one lawsuit that I wanted to speak to you all about. But in the course of that one lawsuit, I got word that it was another lawsuit. One was filed in May of this year, 2023, and another was filed June, the next month of 2023. So those are two lawsuits we're going to be talking about today, and hopefully you all will tune in with me. But there's a federal lawsuit that has been filed by uh, two bus drivers that work for the Blytheville School District. And also there are two, well, not two, but there's another lawsuit. Um, Many of you might remember there was, I think she was a school teacher, a lady who got hit by a school bus. Those are two lawsuits that I want to talk to you about. And the reason that I want to talk to you about it is because I hadn't read anything about lawsuits. And so I would think that whenever there's a lawsuit, it seems to me that the superintendent, because 9 times out of 10, she would be the first person of contact because she run the school district. And to my knowledge, I spoke to one, well, I spoke to actually more than one school board member, and they didn't know anything about this federal lawsuit. So if they didn't know anything about the federal lawsuit, I'm wondering, do they know anything about a lawsuit that was filed here in the circuit court as well? So we're going to get through those two lawsuits, uh, go over them. Hopefully at some time, if you like to call in, you see my number scrolling across the screen there. You can call in, okay? But somebody wanted to see my setup before I go. They want to get into the podcast business, and so I just want to go up here and pretty much show them my setup. Okay, uh, this is my setup. I don't have but three pieces of equipment, actually four. I have my interface uh, system here. It's sound effects. It do a whole lot of stuff. I have my stream deck. It's beautiful. I tell you, it's, whoever created this here, I mean, it can do some everything. Turn my lights on and off. Uh, it can do all different types of animations. I mean, you name it, sound effects. So that's the stream deck. And of course, my laptop and my mic, of course. So those are only three uh, uh, pieces of equipment that I get, and I do have a little software that I use. All the design that you see now, I did that. And so for those of you who are getting into the podcast business, this is my setup. This is my office that I turned somewhat into a studio. And so, but that's that, okay? And so I'm gonna just stay on here for a minute before I go back to uh, uh, my other camera. I got two cameras right now. I'm planning on getting two others that'll shoot different angles. Okay, now, so let's go up here and look at some of this here. I want to talk to you about. Now, first of all, uh, for those of you who don't know, you can. I want to give you these case numbers to these lawsuits. Okay, so I want to go up here and find it right now. Uh, this would be the first lawsuit right here, I believe, that we're going to be talking about. Can many of you see that? That is the first lawsuit there. Deborah, is that Stout? Deborah Stout versus Martha Lucas, Blytheville School District, and the Cincinnati Insurance Company. That's the case number there. I'm gonna leave it there for a minute. You can write it down. And this is in the circuit court, this case right here. 47 BCV 23 159. Okay. So that's the case number for that particular case. All right. So you can uh, retrieve that case. You can go straight to the county uh, court clerk, give them that case number, and you can have them to, submit it to you upon request. You can get it in person. You don't have to actually send an FOI. You can just go in person to the clerk office and you can get this case number and you can read it for yourself. Okay. So that's that. All right. Now, again, there must have been there's another case that we're going to be talking about. And that case is, let me go up here and find it for you. We're going to be talking about this case here more in detail. But this case right here is the federal lawsuit. Okay. This is the federal lawsuit. This is the case that was filed by two bus drivers. As you can see, ERICK Smith and KIZZIE Lucas. That's the case number. This case here was filed June the 21st, 2023. And the other case that was filed, it was on, I want to say it was May something. I want to say May 18th. May 18th was the one with the bus driver. I mean, the bus accident. Okay. But this is the lawsuit that we're going to be talking about today. All right. Let me get this off here where you can see that. I'll go in here and get off this brand. But that is the lawsuit that we're going to be talking about today. If many of you will just tune in and follow us, and we'll get through this thing just as quick as we can. All right. So, but this is the first. That's the last lawsuit. Excuse me, that we're going to be talking about. But let's go ahead and go back to the first lawsuit that I had pulled up. Okay. Which is Miss Deborah Stout is her name. But that is the first lawsuit that we will be talking about. Okay. So I just want to say this here real quick. I'm gonna try to get through this quickly. I know many of you got to go to work in the morning, but I want to get through this lawsuit real quick. I did jab down a few things right here. There was, I want to say, 4 counts with the lawsuit that was filed against the Blytheville School District. This was the bus driver, that case number I just gave you. I'm gonna just run through that real quickly, where you can pretty much see the things for yourselves. It was like 4 counts, and that's what I want to show you all. Okay. Okay, yeah, that's what I want to show you all. Was 4 counts. Miss Deborah Stout. Count one. I'm just reading from my notes here. Count 1 is negligency of Martha Lucas. Okay. That count 1 is called ordinary negligence, okay, of the particular bus driver. And what that is saying is that in count 1, holding employer responsible for an act of employee. Okay. You're holding the employer responsible for the act of the employee. That's count 1. As I stated, this is count 1 is ordinary negligency of the particular defendant, Martha Lucas. Count 2 is negligent harm. Okay. Now, actually, these counts, what the plaintiff is alleging is that a lot of these things that occurred was a result of um, not having adequate policy and procedures. As I always say, that when lawsuits are filed, whether it's the school district, whether it's the police department, the first thing that is going to be asked for is policy and law, okay, or regulations or what have you. But those are two things you can bet. And yes, don't want to leave that out in training. Those are three things that they're going to ask for: policy, um, uh, policy and procedures, statutory law, federal law, whichever, and of course, training. You can bet those are three things they're going to be uh, uh, they're going to ask for as they begin their investigation. Okay, the third count is negligent retention. I didn't tell you what the second count was for. Negligent hiring. Negligent hiring, what they was claiming that they didn't have adequate policy and procedures. What they're saying about the negligent hiring, I'm reading here. It's a claims the driver was not justified. What the drivers were not qualified nor competent to safely operate the bus. Now I don't know what that means. Uh, I imagine they wouldn't have a bus driver. Certainly, they wouldn't have a bus driver driving that wasn't qualified. I don't know if they're just saying, even though a bus driver is qualified, where are the policies and the procedures in terms of uh, the do's and the don'ts, if you will, in regards to the bus driver? You know, are they aware of the do's and the don'ts as it relates to coming into, let's just say, pedestrians, coming into the traffic flow where it's oncoming traffic? I mean, are there policy and procedures in place that the bus drivers should be aware of? Okay, just simply telling them by word of mouth or what have you won't get it. There must be policies written into the Blytheville School District books. Okay, so that's count two. It's not before it counts. Count three is negligent retention. Same thing. They go back to policy and procedures. Are there policy and procedures in place that will prevent Blytheville School District from retaining a, let's just say, bus driver who is problematic? You know, maybe done had some accidents, maybe on the phone. I'm told you can't use your cell phones when you're operating the school buses, you know, and so you do that by ways of, I guess, evaluation of your employees. But in any case, uh, how do the district manage uh, retention of continuing to keep employees who may be problematic? Uh, are there any red flags that they can look at to where would prevent them from yet maintaining or retaining uh, a bus driver who's just not working out? Last count is direct action. Um, Direct action actually is plain and simple. It's speaking of the accident itself, the people who harm you, you directly holding them responsible. Okay, and I imagine since it was the bus driver that accident, well, uh, accidentally, I'm gonna say accidentally. I don't think the bus driver would just intentionally uh, hit someone. I mean, that's just me now. I'm not reading from the lawsuit. That's me. It's just my opinion. But anyway, direct action against the bus driver, as well as the Blytheville School District, and of course the insurance company. The insurance company happened to be uh, Cincinnati Insurance Company. They have somewhere like $100,000 policy. I guess that's pure driver or pure employee. I don't know if that's a blanket cover or is it just for the transportation department. But there is $100,000 liability coverage. And so my understanding, Mrs. Stout, the school teacher, she has medical bills. Um, Medical bills are still coming. And so I'm guessing that that is probably one of the reasons that this lawsuit was filed. Of course, uh, the school district did file an answer, and basically they trying to get the lawsuit dismissed for a whole lot of reasons. They're saying that it's without uh, this jurisdiction is a problem. It's not the proper jurisdiction, the way that they were served. Um, the attorney is saying that there should be a case where, workman comp should be hearing. And so they trying to get the case dismissed. And in the case that they do get the case dismissed, if they're fortunate enough to get the case dismissed, then what the attorney is asking for then is asking uh, in the case that they say, throw in immunity, just like police immunity, uh, I'm pretty sure the bus driver is going to be granted immunity because she drives for the uh, Blytheville School District. So I'm pretty sure if no one else, the Blytheville School District will get immunity. They're also trying to have the insurance company uh, uh, to be dismissed from this lawsuit. Okay. And so that is the the lawsuit as it relates to that first lawsuit, Miss Deborah uh, Stout. Uh, now it says in here, I'm gonna read you a little bit of this lawsuit. It claimed that it happened January the 24th, 2022, approximately at 3:43. Plaintiff, a Blytheville School District employee, was leaving work and had exited the Blytheville Middle School building, headed toward her car in the main parking lot. At the same time and place, defendant Martha Lucas was operating a 1992 Bluebird bus and was pulling into the middle school parking lot to get in line for the bus children to be released. A plaintiff, as plaintiff began to walk to her car, the defendant, Martha Lucas, continued through the open parking lot, navigating her bus toward the plaintiff. The plaintiff waved at defendant Lucas, who never stopped it, but instead continued on her course and violently struck the plaintiff with the very front middle part of the bus. Excuse me. Excuse me. This resulted in plaintiff being thrown to the ground and rendered unconscious, requiring emergency air evac to rush the plaintiff to Regional 1 in Memphis, Tennessee. This as a direct and proximate cause of defendant. The plaintiff suffered serious personal injuries and damage, as explained more herein. So that is just explaining how the lawsuit occurred uh, uh, in regards to the bus driver. I did. That's what took me so long, y'all, to come on. This is the lawsuit that I'm reading now, that I'm going through for you all. Uh, like I say, I didn't have time to really read through it all, and I didn't want it to get much late. But I did give you, as they say, the nut in the shell. Uh, Missed out, filed a lawsuit. That lawsuit was filed, as I say, it was May 18th, 2023. I don't know if the bus drivers, excuse me. I don't know if the school board is aware of this lawsuit. I know this federal lawsuit that I'm getting ready to show you all. The school board is not, uh, they're not aware of that lawsuit. Okay. And so uh, that's not good because the school board or somewhat is going to have to protect all, protect the Blytheville School District against all liabilities. Okay. And so they need that information. They need to have that information uh, in their hands where they can be abreast to exactly what's going on if the superintendent is conducting business with these defendants. That's okay. But I would think that whatever communication that she's having with the defendants and their attorneys, then I would think that she have a duty and obligation. In fact, I would go so far to say she mandated to share that information with the school board. So why is it that the federal lawsuit that we're going to talk about in a minute, why aren't certain board members not in knowledge of that federal lawsuit that just been filed? What's the hush for? Okay, maybe some members was told, others wasn't, but I do know that there are school board members that didn't know about this federal lawsuit. Okay, it say the defendant, they named Miss Superintendent Perkins. They named her as being the person appointed as its registered agent, Veronica Perkins, superintendent for Blytheville School District at 405 Park Street, Blytheville, Arkansas. Okay, and I pretty much done read you all, like I say, the nut and shell about what this case is about. So we're gonna go ahead and turn the page on this. So I'm gonna go to my board first, though, to see if anyone got any questions on this first case here, as it relates to Miss Deborah Stout versus Martha Lucas, Blytheville School District, and the Cincinnati Insurance Company. Okay, again, I'm getting ready to take this off. I'm giving you all an opportunity. That is the case number. Go down to the Mississippi County clerk and give them that case number. It's about, I want to say, the complaint itself is probably about 5 or 7 pages, 2, 3, 4, 5, 6, 7. Okay. The complaint is 7 pages. And of course, the attorney for the school district did file an answer. Let me see who's the attorney. I know they have an attorney here locally in the city. But right here, they went out and hired an attorney, Barbara Law Firm, 425 West Capitol Avenue, Suite 3400, Little Rock. So they actually went out and hired an attorney from Little Rock to handle this case with Mrs. Deborah Stout. I thought perhaps they might have used a school attorney, Mr. Bobby Coleman, but they went another route. I don't know if that's because this is a federal lawsuit. I imagine that Mr. Coleman is authorized to practice federal law. I mean, I don't know. But anyway, that's that, okay? So let's get out of here and let's go and talk about this case right here. This is the case that we're going to be talking about today, all right? This one right here is I got all my paper thrown around here. Let me see which is which. Oops. Okay. Oh, here we go. Okay, now this is the one here that we're going to be talking about, the federal lawsuit. As many of you know, that I broadcasted on, I might have did a Facebook Live, I don't know, but I broadcasted on this here several times. I even advocated for the bus drivers, trying to get them some justice with the superintendent and the school board not wanting to pay them for hours that was worked. And so they did hold a hearing for Mr. ERICK Smith. He did have a hearing back in, was it April? I want to say April or May, but I want to say it was April. He went before the school board and he made his argument before the school board that he should be paid for his hours that he worked. At that time, it was like about maybe $400 that he was asking for. And of course, the superintendent didn't want to pay him. Okay. And so Um, that is the purpose that he went before the school board to, address the school board, his grievances. And but of course, the school board had a deaf ear. Uh, they, by a majority vote, they agreed with the superintendent that Mr. Smith should not be paid his $400. Okay, so he filed a lawsuit along with Miss Kizzie Lucas. Although there was other bus drivers that also had similar, if not the exact same complaint, uh, they have not enjoined on this lawsuit yet. And so I want to say this here before I go any further. Bus drivers, you need to stand up. Okay, you need to stand up. This lawsuit has already been filed. You need to stand up. Join this lawsuit and join on this lawsuit. You will be considered what I call it's more like protection. Right now, you got no protection. You have nothing to protect you from retaliation. That's what I'm talking about, protection. So, in the case of Mr. Smith and Miss Lucas, if there's anything that could be deemed as retaliation, that's a whole nother lawsuit. You can't retaliate against employees because they decide to file a lawsuit against you. That is a whole different case. You can actually lose the lawsuit that you file, but you can be granted a judgment for them retaliating against you. You can't retaliate. So, bus drivers, bus drivers, you need to enjoin on this lawsuit. You have the information that you need to submit. And so hopefully you will send that information in. Okay. So, but back to this lawsuit. We're gonna run through this real quick. How much time we got? I want to make sure I don't go over. Uh, anyway, we get it later. Okay. I just jabbed down a few things on this. I'm thumbing through the pages. I do have it up here. I put it on the screen. You all can roll with me. Uh, look like we're going to page 4. Uh, going to page 4 is where we're going to. Okay. Uh, and this is where we get to factual allegations. Can you all see that? Factual allegation. Turn your phone landscape. Go down to 27. We're going to skip through this here. We're going down to 27. It's saying in previous years, plaintiff and other similar situated bus drivers received additional hourly rate for time spent driving these routes. Okay, we go to the next page, 27. I mean, page 5, excuse me. Uh, and if we drop down to 30, if I'm just skipping around, okay, it say during the 2022-23 school year, defendant stopped at paying plaintiff and other similar situated bus drivers, employees, their hourly rate for all the time spent driving additional routes. They had additional routes in addition to the things that they were doing for us picking the kids up in the morning and returning them home. They also took on uh, additional work, whether it was driving the bus to certain events, then after driving there, sitting, waiting on them. And so they did other things, of course. Okay, excuse me. It's a defendant on 31 where we at. Defendant also reduced the plaintiff and other similar situated bus drivers employee hourly pay for the period of time they spent waiting for students and their regular hourly rate to be lower to a lower rate. Now just go back up there a few minutes what we was talking about on 30 there if you can look uh number 30. This was the 22-23 school year, you all. Do you remember me talking about that? The contracts had already been signed and agreed upon. And many of you who know about contract law, that when you sign a contract and both parties agree to all the things within that contract, uh, you can't change that contract. It's a contract. It's an agreement. You can't even change one word without the other party being in agreement. I mean, that's just as plain as day, and so that was that. 32, did we read 32? 32. It's a defendant stated to plaintiff and other similar situated bus drivers, employees, that they are paid 2 hours in the morning and 2 hours in the afternoon. 33. Defendants stated that bus drivers should not be paid any additional fund for driving additional routes to deliver faculty and staff to other locations for field trips, athletic events, and extra curriculum activities, even though plaintiff and other similar situated bus drivers employees are required to wait at these locations to transport them back to school and cannot leave their location to engage in other activities. This superintendent won't, I just have to just call it. It's almost like she want the bus drivers, she want them to work free. You know, these are some things that they have been doing for years until this superintendent came. She changed everything. How do you change a contract that has already been signed? You might not like the way the bus drivers are paid, but it's a signed contract. Now, if you got a problem, you need to take that up with the 23-24 school year. But in regards to the 22-23 school year, I just don't see how the district gonna win that. I don't care what attorney they get. I just don't see how they're gonna win that. Okay, we almost finished, y'all. We're going to page 6, and name 17 pages. We're gonna jump through it real quick. Okay, we're going to page 6 now. Okay, and we're going down to 40. This is what we're talking about. Representative, it was 3. I want to say it was 4 actions that they were taking against the Blytheville School District. Okay, and right here it say plaintiff brings the FLSA. That stands for the Fair Labor Standard Act. Okay, that's what that stands for. They actually brought they brought 2 claims against up under the FLSA, which is the Federal Labor Standard Act, and they also brought 2 claims up under what is that? I want to say the American. I have to go back and look at it. But we'll get to that later. But right now, they brought 2 lawsuits upon this here one. In 40, it said, did I read that to you all? It said, excuse me, plaintiff bring their FLSA claim on behalf of all hourly paid bus drivers employed by defendant at any time within the applicable statute of limitation period, who were classified by defendant as non-exempt from the overtime requirement of the FLSA and who are entitled to payment of the following types of damages. Okay, I really need the bus drivers to talk to me more about that. I'm just not in knowledge of, I did look that up. The difference between non-exempt and an exempt employee. And so I'm not figuring how this tie into whether it works for or against the bus drivers, non-exempt versus exempt. And so hopefully if the bus drivers, any of you all are listening, perhaps you can explain that to us, okay? And down to the very bottom, A, it say payments for all hours worked, including payments of a lawful overtime premium for all hours worked for defendant in excess of 40 hours in a work week. Okay, and they asking for a lot of things. They asking for liquidated damages, attorney fees and costs, it just go on and on and on. They asking for a lot of stuff. We're gonna drop down to E. Okay, it say these bus drivers who we're talking about, they were subject to defendant common policy of improperly calculating overtime pay for hours worked it over 40 hours per week. And so there's a problem with them improperly calculating the pay for the bus drivers. And so uh, that is one of the arguments that the attorneys will be making upon this FLSA, the Federal Labor Standard Act. Okay. Uh, let's move right on through. We're halfway through, y'all. This next one that action two claims upon it, that's what it is. The AMWA. What that actually stands for is the Arkansas. I just saw it somewhere. Where we at? Just saw it. Arkansas. They stand for the Arkansas Minimum Wage Act. I think that's what they stand for, the Arkansas Minimum Wage Act. So there was two claims also that came upon this. All right. And it basically making some of the same similar claims as was filed upon the FLSA, the Federal Labor Standard Act. Okay. And so they basically making the same claims. It's just two up under the FSLA and the other two up under this Arkansas Minimum Wage Act. Okay. We're skipping around. We're going to page 10, 7 more pages, and we done. So let's skip on over to page 10. I'm just trying to show you a little bit that was, this is the first claim up under the FLSA. Okay. We'll go down to number 60. Here we go. It's during the period relevant to this lawsuit, defendant classified plaintiff, which the bus drivers, as non-exempt. What do that mean, bus drivers, if you're listening? Non-exempt from the overtime requirement of the FLSA, despite the entitlement of plaintiff to minimum wage and overtime payment under the FLSA. Defendant failed to pay plaintiff a lawful minimum wage for all hours worked and a lawful overtime rate of 1.5 times their regular rate of pay for all hours worked over 40 hours in each work period. Defendant 62. Defendant failed to properly pay minimum wage and overtime wages to plaintiff stemmed from defendant acts of reducing plaintiff hourly wage for wait time. They had to wait, like a ball game or something like that. You got to wait till they finish playing the game. Well, what the superintendent was doing, she was saying, since you're waiting and the bus is not moving, your pay will stop until this bus begin to start moving again. So let's just say the bus driver sitting for 2 hours until they finish the ball game. So when they get back on the bus and the bus start moving, that's when the bus driver's pay will begin again. The contract has already been signed. Now, if you want to do that for the 23-24 school year, that's when she should be talking about that. Okay. But she had no authority, at least by law, to reduce their pay and not pay them properly for overtime when it's already written into the contract. All right. So that was that. Where we at? Defendant conduct. I want to really read that 63. Oh, here we go. It's a defendant 62. Where we at? 62. Defendant failed to properly pay minimum wage and overtime wages to plaintiffs stemmed from defendant acts of reducing plaintiff hourly wages from wait time and not paying plaintiff, I'm probably reading this over again, for all hours spent driving additional routes to transport student and faculty for field trips, athletic events, and extracurricular activities. 63, defendant conduct in praxis as described above has been in ills: 1, willful; 2, intentional; 3, unreasonable. 4, arbitrary. And last, all of this was done in bad faith. You know, you hear the word good faith. It's okay to negotiate as long as it's in good faith. All the acts of this uh, superintendent and this school board, because they could have intervened, but they chose not to. As the lawsuit stated, it was where we at. It was willful, intentional, unreasonable, arbitrary, and bad faith. Okay, so that is that. We at page 11. Uh, this is also page 11 where we at. The second aim for relief, like I say, this basically talking about the same things. I'm going to turn it over to you guys because uh, after I run through this here, I hear from you all, and then we can call it the night. All right. And it's actually bad for themselves. And so basically, I'm reading to right now because I didn't have time to read a lot of this here. Uh, it's basically saying the same thing. You have to go over here, and I show you right here at this bottom here. Let me see if I can take that up one more time where you can see it. Okay, let me try to pull it over a little bit. No, I got to drop down. Okay, let's go back the other way. Okay, now right here, it say each hourly pay bus drivers, uh, each hourly pay bus drivers employee who, within 3 years, that 3-year contract we're talking about, preceding the filing of this complaint, drove additional route as part of their job duties for a defendant. And so all these bus drivers, not just these two, but if you're a bus driver and uh, you was treated somewhat similar, you're gonna get paid too. And that's why I'm telling you, bus drivers, you need to join on this lawsuit. You have an interest in this as well. Mr. Smith and uh, Mrs. Lucas, they should not be carrying this water themselves. You all should join on this lawsuit. You have the information. Please call the attorney, the law firm. All right. Uh, so let's go ahead and wrap this thing up, y'all. Uh, I don't know if that's where they dropped their pay down. Let's go over here to 81. That's where they dropped their page down right here. If you can see that 81, that is a state statute that they quoted it also, require employees to pay all employees a minimum wage rate of $11 an hour for all hours worked unless an employee meet the exemption requirement of 29 USC, that's a federal statute, and accompanying Department of Labor regulations. And so that is that. Like I said, we're not going to read no more of this here. That's pretty much saying the same thing on this other side over here, where it got where are we? Right here, it's each hourly paid bus driver employee who within the 3-year proceeding and filing this complaint drove additional routes. So you got the minimum wage issue. In terms of what they agreed upon, they went from $20. Well, they still was paid $20, but the $11 that is to where they reduced them on the the sit time, wait time, yeah, for driving extra duty routes. So I think this is it, you all. 16 didn't have nothing on that. 16 is just simply saying that's the closeout page 16. And so it just goes to show it's a whereas premises did that premises consider it. Plaintiff ERICK Smith and plaintiff KIZZIE Lucas respectfully, let me pull that over while you can see it. Respectfully pray that defendant be summoned to appear and to answer herein as follows: that defendants be required to account to plaintiff, the class and collective members and the court for all of the hours worked by plaintiff and the class uh, and collective members and all monies paid to them. I'm not going to name all that there, but you can pretty much see it right what they're asking for. They're asking for a declaratory judgment. Um, how they violated the Fair Labor Standard Act and as well as the American Minimum Wage Act. Um, they asking for damages uh, for all unpaid compensation. What else they asking for? Judgment for damages for all unpaid overtime, judgment for liquidated damages pursuant to the Fair Labor Standard Act. It just go on and on and on. In order directing defendants to pay plaintiff and members of the class in collective prejudgment interest, reasonable attorney fees, and all costs connected with this action. Such others and further relief as this court may deem necessary, just and proper. Okay. Respectfully submitted, Eric Smith and KIZZIE Lucas, each individually and on behalf of all other similar situated plaintiffs. Okay. And their attorney is out of Little Rock by the name of, what's that, Lindsay No law firm, law office. Oh, excuse me. And so that is that. Okay. I know it was pretty lengthy, pretty long, but uh, I wanted to get through that. Um, I wanted to get through that to come back and and let you all give your comments or what have you. So let me try to go back. So that's where we at. Okay. Um, so talk to me, people. So what do you say? Do you think that um, they have a case here? Do you think that this lawsuit should have been filed? Do you think that the superintendent is using too much of a strong arm, uh, uh, on the do's and don'ts in terms of, uh, running the district? Uh, but that is the two lawsuits. Again, the school board need to be aware of these lawsuits. Okay, this superintendent continue to always like to go to court, playing with other people's money being you and myself, the taxpayers. She was involved in a lawsuit, one of the school districts on the Northwest End. And I'm told, this hearsay, I don't like to repeat it, but I guess the lawsuits that was filed here in Blytheville, it was almost like, this is hearsay, this ain't her first rodeo, you know, meaning, she done been involved in lawsuits before. But like I say, it's easy to fight lawsuits when you are spending other people's money. And I don't think it's fair to the taxpayers. The superintendent should inform all school board members of these two lawsuits, not some and don't tell others. If you don't tell, you can tell all seven and don't tell one. That's wrong. You can tell one and don't tell the other seven. That's wrong. You can't just tell the president. If you tell the president and you leave it with him to tell the other seven, then Mr. President of the school board, you need to share that information with your fellow school board members. Okay, we're gonna go to the board. You all see my number scrolling there. If you got the nerve to call and give your comments, do that. Okay, we'd like to hear from you. Give you the time to speak. That's my number that's scrolling, 870-740-1515. Testify, okay? Again, that's 870-740-1515. Let's go to the board right quick first and see what we got. Okay, looking for a question. We see everybody saying the hellos. Hello, Miss Williams. How you doing? Miss Rump, how you doing? Uh, that's Sister Ellen. How you doing? Uh, Good seeing you as well. Miss Tina Easley, how you doing? Um, what is that? That's Miss Williams. Get that money. I know it was coming. They deserve. I'm so proud of them stepping out, filing that lawsuit. I am so proud of Mr. Smith and Miss Lucas. You know, they're not gonna take it laying down. I'm so proud of them. Of course, we got Miss Williams again. That old bus, that old bus should have been shut down a long time ago. That bus is 30 years old. Uh, are you referring to the bus that involves the accident? Uh, well, and like I say, all of that is public information, you all, both cases that I read. So it's not like I'm reading something that is confidential. I will say this here that Blytheville School District, for some time now, you can tell that they're underpaid. I won't call no names, but there has been many cases filed with the circuit court against certain creditors uh, for the uh, Blytheville school employees, whether they classified or whether they classified employees or certified employees. You can tell that they're not making the money that they should make is because they run into some financial strain, and there's a whole lot of cases to where uh, uh, there are garnishments, shall I say, that has been filed against the employee. And of course, when that occurs, you start talking about garnishment, you have to send a letter to the employer, uh, you know, with them presenting what is called a writ of garnishment, that they must start deducting uh, pay from the employee check to give to the creditor. All right. And so they're not making a lot of money. Osceola, we'll be talking about you all uh, since I don't have anybody that want to come on and say anything. We got 52 minutes. I mean, I've been on 52 minutes. We got about 8 minutes to go. I don't like to stay on no more than an hour. So if you all want to talk to me or ask a question or call in the number there, you got 8 minutes to do it. Okay. So there's no questions over here. Uh, and Osceola, um, hopefully I get that FOI tomorrow from the superintendent. Osceola has something going on down there. I received some information a few days ago to where there might have been uh, uh, policy broken to where an employee was hired and they didn't have a proper quorum. And but nevertheless, uh, I think it was three people that met for that meeting. Uh, allegedly, now, allegedly, three people met. The reason I'm saying allegedly is because I don't have that FOI yet. Hopefully, I get it tomorrow. Uh, and so, but allegedly, there was three people who attended a meeting physically in Osceola, Arkansas, to hire a particular person, applicant. And this hiring took place to where a quorum, proper quorum, I think it takes four people to be a proper quorum. They have seven school board members. And they, to my understanding, allegedly, they only had three. And so hopefully I get that information from Superintendent Green tomorrow. If not, then I would definitely go ahead and step it up to see exactly what's the holdup. All right. So if there's nothing else to come before me, I'm gonna get ready to sign off, you all, because I know many of you got to go to work tomorrow. I don't, although I guess I'm running around that I have to do. So if there's nothing else to come before this show, um, I'm gonna have to go ahead and sign off. I will say that it's been good speaking with you all tonight. Hopefully, you all will come back and join me this Sunday. Uh, I hadn't forgot about the Uh, I hadn't forgot about, I changed my screen there too. Uh, I would just leave it there. I changed my screen. I'm back on my main camera now. Uh, but I want to say that for any of you going forward who might want to become a guest on my show, this is your platform. Uh, Shoot me a phone call, leave me a message or what have you. I normally check my 1515, this number that I use for the show. I normally check it in the morning and sometime throughout the day, and definitely before I go to bed. So if I don't check it no other time, I'm going to check it during the mornings, and I'm going to check it in the evening before I go to bed. All right. So if you have any topic that you want to speak on, please uh, text me, and I will get back to you. So if it a lot of hours have went by, it's not because I'm avoiding you. It's because I hadn't checked my phone yet. All right. And so that is that. Is there anything else? I want to say this here before I close. For all you Juneteenth celebrators out there, you need to put your money where your mouth is at now. I know you all saw those Supreme Court decisions that they had. Uh, what was it, just yesterday, or I believe, to where affirmative action, uh, they kicked it to the curb. Okay. So now, if you are a business owner, okay, and you ever heard of set aside Arkansas, for example? Arkansas had something like, I think in any given year, they have something like a $300 million budget. Okay. A percentage of that budget is set aside for minorities, uh, black and brown people, women. They also is considered in that class. All right. And so all of that you can contribute it to affirmative action. You know, if you're doing business with the government, whether it's construction, okay, whether it's cleaning, custodian, or whatever, however business that you do, uh, and you're doing business with the state government or some cases the federal government, uh, the Supreme Court has made it possible that if race is considered um, in the awarding of contracts, you just might not maintain that contract that you get right now. So you have a duty to fight for this thing. You Juneteenth celebrators, now that you're free, make it mean something. The battle is not over. You hear me? The battle is not over. You need to be mobilizing, meeting, planning strategically, that is. And you need to be making march to Arkansas State Capitol. Because believe me, I think where this lawsuit originated was in Mississippi, I believe. I think it was Mississippi. Because believe me, the whole dirty South, Arkansas, Mississippi, Louisiana, Florida, Alabama, Georgia, you name it, all of these states follow each other lead. Soon as uh, uh, a bill or a law is considered that is going to be detrimental to you, uh, Arkansas copycat. They copycat off of their neighboring states. And so Juneteenth celebrators, you need to put your money where your mouth is at. Okay, you're free now. Okay, you're free. Make it mean something. Okay, make it mean something. And but that's all I have. The the bill that was the other law that they struck down had to do with um, a wedding website or whatever, where the person gave a imaginary or some hypothetical situation. In other words, she created it. I think it was a she. Well, what if some two men or two women come to me and want me to uh, uh, somewhat uh, service them in terms of this website wedding deal, and try to throw a claim in there because of my belief? Do I have to do that? Well, Supreme Court say no. No, you don't. That's the first thing. Supreme Court shouldn't have took this case because, first of all, nobody was injured. Nobody was damaged. It was all made up. We're talking about an extreme court that took on a case such as this when there was nothing there. Okay? So now for you interracial couples, you married couples, what if you visiting another state? Okay? Let's say it's Alabama, Kentucky, Mississippi. And you walk in a restaurant, you want to be served. Now the Supreme Court them set it up to where if the owner of that restaurant that you walked into, and I know that we done heard it, to where they try to refer to the Bible, that you shouldn't mix races, should not get married. They gave all kind of reasons. They don't believe in interracial marriages. So now, if you and your husband, you and your wife, who walk into a restaurant, and that person believe that black and white should not race mix, there you go. Again, you got a dog in this fight now. You Juneteenth celebrators, make it mean something. And I can just go on and on and on. You know, we're living in a time now where we better start hanging up our hang-ups, quit hating each other, quit hurting each other, quit harming each other, and come together in unity to be about the bigger picture. Working together that is going to have an impact for the positive on all of us. Okay? That's all I have. Don't have any other questions over here, I don't think. And so with that being said, we got Miss Connolly. Is that Miss Connolly? Yes. She simply just complimented me. Keep up the good work. How you doing, Miss Connolly? But anyway, ladies and gentlemen, that's my show. You all catch me Sunday. Hopefully, I'm gonna try to get to where we're going to be talking about the phone rapes out at the boy, I'm sweating, out at the county jail, and in some cases the Arkansas Department of Correction as well, where you're paying all these ridiculous fees. Okay, and so that's pretty much it. Look like I went, what's that, 3 minutes over? Not bad. And so again, I want you all to come back and join me this Sunday, and we're gonna try to do what we do again. Okay. So I want to say, may God bless you and may God keep you until the next time we see each other. Okay. So peace and love. God bless and good night.